I just want to go ahead and announce that today's keynote is Dr. Amit Elazari speaking about hacking policy and policy hacking, a hacker guide to the universe of cyber policy. So without further ado, welcome to the stage.
Thank you. Hi, everyone. I want to see who we have here in the room. How many of you have been to my BSides 2018 talk about legal safe harbors? Okay. So not all the room, but a couple. That's good. No worries. I'm going to give you a preview here, too. How many hackers? How many lawyers? How many regulators? Hey, Jack, you're both, all of them. So, kidding. You'll hear about Jack, too. Well, I'm really excited to be here. My name is Dr. Amit Elazari. Keep the doctor, just Amit. You might know my sister, Karen Elazari. Woo! Co-founder of BSides Tel Aviv, largest hacker convention in Tel Aviv, coming at you this June, end of June, during Cyber Week. Mark your calendars. We all know how much we love our BSides. And are we making progress here? Okay, great. Okay. Presentation. Oh. You want to load from the PDF team? BSides team? I don't know why it's not. Sorry. This is still the Intel machine, so I'm like, you're getting all the Intel vulnerabilities here? Here we go. We heard that noise. Yes! Team, we got it. I just need the clicker. Here we go. Good. Sorry about that. Those of you who know the Elazari sisters know it's a fast ride anyway, but since we are 15 minutes behind, you better, strap on for this ride. For those of you coming in, whoever is going to come in is going to get a direct upgrade to the front row seat, free, which is kind of cool when you present here. Well, this is, as I said, I'm Amit Elazari. This is going to be a fast ride into the universe of cyber policy law. But I first want to tell you why I'm here. So a little bit about me. I'm actually a lawyer, but I'm not your lawyer. Today is not legal advice, but I'm also technical at an Intel, which I'm going to leave, by the way. May 1st is my last day at Intel. I'm also a principal engineer, so it's a bit confusing. I guess I'm a little bit of all. My background is legal and technical. Obviously, I'm Israeli. I spent some time in the Israeli intelligence forces where I hacked things that I cannot talk about. Then I moved to work in another semiconductor industry, a very important one, photovoltaics, where I designed solar power stations. Then I decided that I love the law so much that I have 4 degrees, 3 of them in the law. Why is a very good question. I agree with you all. You're going to hear a little bit about it today. But I went to Reichman University, where I still teach cyber law today in the master program. And then I decided that I also need to practice law, because that's the process in Israel, and I became a big law and M&A lawyer. So I helped startups and VCs of all size. One of my biggest acquisitions was Annapurna, yet a chip company. Yes, there is a theme in my life. I guess I love hardware. And I helped them with their acquisition. But then an opportunity arose to become, I guess, the first Israeli student that got accepted to the direct track doctoral law program at Berkeley. Now, why Berkeley? Because it's full of hackers. So I spent most of my time at Berkeley with hackers. It's also the best technology law school in the world. And in 2018, I graduated at Berkeley with the help of all of you here. And you will learn how. So my passion is this intersection between policy, engineering, innovation, technology, hacking, and law. And I know these are a lot of words. But my goal today is to show you how all of you right here, some of you in the room, are already policy hackers, right? And what does it mean to engage in this universe of cyber law and cyber policies, and why you should embark on this complicated journey. So this is, as I said, a journey into space. We're going to land on a few planets. And as I promised in the abstract, we're going to have some guest speakers, because when you go into space, you don't know which aliens, which adventures, which laws you're gonna come into. Okay, so I already told you that I'm passionate about law, and I spent some time in that beautiful university at Berkeley, but I didn't tell you what I did there. So first of all, I decided that it's very cool to see how hacking methods and operating systems of Android can potentially at scale find COPPA violations. So COPPA is a privacy law. Who here saw the Silicon Valley episode on COPPA, $40,000 per violation? Yes, I'm seeing some nods. It's a very important law. It protects children's privacy online. It's gone through some revisions, but one of the biggest complexities that we have in the policy and law landscape is how do we enforce it? And here's the first area where we see the aid of technology and hackers. Hackers are helping us to enforce the law. In fact, technology is a strong enabler and a positioning of policy and laws. And technology, as Lawrence Lessig tells us, and code can be policy too. So I spent some time working on that. That's how I got my first bug bounty. It's not my own. This was co-authored with some brilliant hackers from ICSI, Professor Serge Egelman team, resulted in $10,000 from Facebook and Meta, and $5,000 from Google, but also a settlement with Google by the Attorney General of New Mexico in $120 million. So I guess the combination of technology and enforcement can get a little bit powerful. But the cool stuff is we took the $15,100 and we went to Tao and we skied there. And that's what I did after RSA 2018. And guess what? As opposed to my friend's experience, I did not break any knees and any bone, so that was really cool. And if you want to check that out, that's AppCensus. But this is where I first got to kind of know the joy of working with hackers. And what can we achieve if we take policy and hackers and computer scientists on the same paper? Obviously, I was an academic, so this is a paper too. It got the Usenix, I think, paper award, as well as the PETS paper award, and that's pretty cool. But what's most important, it taught me about the value of bug bounties. So this is my first bounty is actually a data abuse bug bounty, which made me think already in 2017 about this interesting concept. Sven, where are you? Raise your hand. I told you guest speakers. Coming at you, DEF CON 2023, hopefully the biggest hacking event for AI ever. Yes, an algorithmic bug bounty. Guess what? We can bring bug bounties to algorithms because the power of the crowd is not confined to security. And we're going to talk about it when Harley is going to talk about anti-hacking laws. And you will see that a lot of the case law and papers coming from security research have a lot in common with algorithmic auditors, with researchers that are uncovering issues in privacy and in data. So I invite you to think about security and cyber law as a piece in a much broader domain, enabling the crowd, the hackers, the thinkers, and above all, openness and transparency. But of course, I'm a lawyer. So, not your lawyer, but a lawyer. So I fell in love with contracts. And I wrote my entire dissertation at Berkeley on very long contracts. In fact, 2018, I stood here and I said, yeah, I'm that person that reads those terms of use. Guess what? I also have a hacker sister. And my sister tells me all about the power of hackers. As she standed on the TED stage in 2014, by the way, friend, mentor, inspiration, my best friend in the world, many thanks to Karen, who is the reason why I'm in cyber, so it's a very important lesson. She tells me about bug hunters and their challenges. She tells me about hackers and the power of security researchers. And since I'm already obsessed with very long contracts, I start to investigate this phenomena of bug bounties, right? So how many bug hunters in the room? I know a couple. Don't be shy. Yes, you. Yes. How many security researchers that got a bounty? Maybe not full time. Couple. Bug bounties are this amazing phenomena where we as corporations, organizations, all the way from Intel to Starbucks to Silicon Valley giants in the 90s to the Pentagon. And I see you here, my friend Jack Cable, one of the first teenage hackers to hack the Pentagon, to the US government, to the European Union, leverage the power of hackers at scale to not only allow them to report vulnerabilities and get money for their time, but for me, create the first more legal environment where hackers can truly celebrate their skill set with maybe just a little bit less of being legal threatened. So I get to know, and I'm impressed, and I just get fascinated by these amazing human beings, like this friend of mine right here, Jack Cable, and the power that community can have and what they find and how it inspires them, but above all, what we can learn from them and what lawyers and policymakers can learn from them. And guess what? What lawyers and policymakers should be doing for them, and maybe how they can also become policymakers. So naturally, after you read a lot of contracts of bug bounties, and you read a lot about cybercrime and computer crime laws, you get to know this law, the CFAA, the Computer Fraud and Abuse Act, the prominent federal law in the United States for anti-hacking with criminal and civil liability for unauthorized access. There are a couple more like the DMCA. You're going to hear all about it from my friend Harley here, who's one of the best lawyers and policy people in the world for that. And I discovered that bug bounty contracts create a little bit of liability at the time, this is 2015, for hackers. Why? Because the same bug bounty program contract that tells you please hack and I will pay you for the vulnerability refers to the end user license agreement that says what? Don't hack me. Not the great solution. So obviously, remember, I'm a law student, what do? I write a very long paper with a lot of footnotes, and it has to be 50 pages because I'm writing my dissertation in the law. That's what I do. But is it enough to do change? No. I am talking with Karen, and as a true aspiring hacker, I create a GitHub page. Now I have a GitHub page, and in my GitHub page, I have contracts. Guess what? Yes, it's a repo with contracts. And then, as a true hacker, I create a Hall of Fame. For what? For bug bounty contracts that have slightly better protections for hackers. We call that the legal safe harbor. But that's not enough. That's like me, Amit, I'm doing papers. That's not enough for a difference. And Taylor tells me, come to DEF CON. Meet Casey, meet Wendy, meet Jack, meet Jason. Meet all my friends, meet Sven, the hacker community. You have something here. You're just a student, but maybe they will help you. So I do a little bit of that. And as I enjoy speaking, I start doing the show. And I tell the hackers, we need to fix this. This is not enough. And I come to BSides, my first talk ever. It's embarrassing. You should hear my accent. Too fast, not the best speech, not the best talk. Check it out online. 2017, this is DEF CON. First question I get. But Amit, this is so theoretical. Who would ever want to sue someone who is participating in a bug bounty? Right, they're in a bug bounty. Who would ever threaten a legal, who would ever send a legal threat letter to a hacker in a bug bounty? Well, you can check out the 2018. I told them in the room, don't wait for it, it will happen. Guess what? It happened. That's a preview. Check out the full talk if you want to hear about it. But I come here to BSides, and this is why I'm telling you, all of you in the room are already policy hackers. Because when I was a student, I came for this room for help, and the room has provided. The community came together, and when I sat here and I said, hey, we need to change this, and you have the power to change this policy reality. And the details don't matter. That's not the message today. You can go online and find all the nuance on how the CFAA and the DMCA and the contracts and over that, all that created the situation. Here's what matters. The community has the power. And if we engage in the conversation, if we open and educate and make everybody aware and explain to them where they're at, why policy and laws matter, they would engage. And this, with the power of Casey, Disclose.io, and all of you in the room, has garnered some results. So this is me as a student. Look at me with my gear, Berkeley Law, through DEF CON, hacker t-shirt. My sister told me, never wear a suit for a hacker conference. No, I'm joking. She told me, be yourself and celebrate it. And I'm doing this today with my red jacket. But you can check it all online. But here's what's interesting. And I'm actually going to take a moment to do this because I think it's a very interesting illustration. Let's see if it works. You probably can't hear it. Yeah, you can hear it. OK. So you're just going to have to trust me on this. Check out this presentation and what I said to this room in 2018. I said, here's what I envision. I envision a future where hackers will not hack if there is no safe harbor. I envision a future where from 4 programs with safe harbor, one of them the US government, DoD, by the way, very cool work by Charlie, by Roro, by Katie, Hack the Pentagon, many others. Leonard Bailey, of course. There is no talk about CFAA, that doesn't mention how much he was a great inspiration in this field. I told them, I imagined the future where this was the standard. And I told this community, and I was a student, I told this community, this is up to us, the people in this room. You can make this work. The community has the power to change this today. And you don't need policy reform. All you need is to feel a little bit more inspired and engaged to think about policy and what it matters. And then people like me, like others, like Jack, everybody here in the room, to open up and share from the knowledge, and then we simplify access to this area. So this worked, and I got the attention of a few very great hackers like Casey, like Jensen, like Jack, and they were like, oh, we're not going to hack until you fix this. And they were here in this room. And then I convened the platforms, fast forward, a couple of companies adopted Safe Harbor. This includes Elon Musk. That's how I met him at DEF CON. I actually got a challenge coin from him, one of 30 or 40 in the world. Yoni Ramon, good friend from Tesla, made that happen. Not for hacking a Tesla, but this is a challenge coin. I love it. But for fixing the program, and guess what? They did something very cool. I think still one of the only maybe 10 in the world right now on this. They figured out the problem with hacking Teslas is access to Teslas. And that people don't want to test their own Tesla because there is a problem, there is a hackcident, Katie Missouri's term. Yeah, you need to fix it, and it's not free. Because the hacking would violate, guess what? Another contract, the warranty. So they fixed that. And if you have a Tesla, people, you can absolutely register as a pre-approved security researcher on the website, hack your Tesla, and if something happens, they would fix it for free. This is the power of policy and law. So a lot more researchers now have access to Teslas. But here's where it gets really interesting. Casey here took the challenge and invited, with all his prior work and my work and others, to co-found Disclose.io, an open source initiative aimed to increase awareness to this problem of contracts stifling research because of interactions with anti-hacking laws. And this was, I want to say 2017, just to give you, this is Disclose.io, and I just want to inspire you to think about the trajectory here. 16, I start my research. Only 17 companies in the world with a bug bounty that says, if you hack me, I will not pursue legal action in the bug bounty contract. 2017, we start legal safe harbor. As I told you, I had like I had, check it out on the talk. I had 4 companies when I came here to speak. We formed Disclose.io. We start talk about it. We get the support of the hackers. 2018, HackerOne and Backroad changed their default terms. Thousands of companies using their services, including in the private bug bounty market that we don't have access to, start to adopt their language. Tens of thousands of hackers are more protected because of that language. This is contract. This is not CFAA reform yet. This is just a contract that is applicable at scale. Think open source license, think Creative Commons, for thousands of hackers. 2020, friends in CISA, in DHS, Cameron, Jack, others decide it's a good practice. It's a public policy imperative to help the hackers when they help us and provide vulnerability reporting. They issue a binding operating directive saying all federal agencies, not only will you have a vulnerability disclosure program, you will address or try to address or mitigate the legal risks of the hacker and provide a safe harbor. This is still 2020. We get Van Buren. You will hear about it from Harley. First Supreme Court case on CFAA in 20 years dealing with the issue of authorization. The entire security research community, auditors, generalists, everybody scraping, everything is at stake in the Supreme Court. The Supreme Court gets free opinions. We call it amicus briefs from third parties referring to this problem, including one from Disclose.io, with the support of hundreds of hackers and tens and hundreds of companies. Guess what? 2021. The research, this is, by the way, for me, I did some stuff in my life. This is my proudest moment. The Supreme Court cites this work in contracts when it makes the decision. We still have problems with Van Buren, but to narrow a little bit more the interpretation of CFAA and anti-hacking laws impacting all of us here in the room. Remember, 2016, this is an academic paper. This is 4 provisions of contracts with 4 companies. This is the power of policy. 2023, Disclose.io, thank you, Jack, is referred to in Jen Easterly, Director of CISA, DHS, Department of Homeland Security, major agency for critical infrastructure and cyber protection, speech in Carnegie Mellon. 2023, Disclose.io. Check that out. Secure by design, best practices. All of you critical infrastructure operators, all of you manufacturers, coordinate vulnerability disclosure programs. But with what? With safe harbors for researchers. What else we're going to see in 2023? I'm going to make a prediction. The EU Cyber Resilience Act. If I have time, I will talk about it. In my hopes, in my dreams, all manufacturers selling products to Europe, not only having vulnerability disclosure programs so hackers can know where to report to issues, but with legal protections. European Parliament coming at you, 2027. We'll see if I, with your support and Harley's support, make that happen. I hope so. So this is a story on how you are already a policy hacker. Because guess what? When I came here to 2018, 2017, to DEF CON, to BSides Las Vegas, to BSides San Francisco, when I spoke on this issue, this community has provided. This room has provided. And I tell you, no way this would ever happen without the support of anyone in this room and the support of the community. This is the power of the crowd. You too can engage and should engage in this space and world. So let's hop in. I already said it's not legal advice. I'm going to say a few words about how this landscape is complex and what is changing in it. And then I'm going to invite Harley to tell you a little bit more about anti-hacking laws, why it matters, and how you can engage. A little bit about security policy. Again, strap on, fast ride here. What do we see in the environment? Policymakers react to vulnerabilities like society. Every key vulnerability and attack brings a wave of new legislation. Cyber law is perhaps the most complex, dynamic, impactful piece of domain legislation, in my opinion, that we have today. The Mirai botnet. How many of you are aware of Mirai? We have a couple events. Huge botnet, partially happened because of default passwords, right? The bot taking the devices, not because the hacker wants to spy on someone toasting or coffee making, right? Abilities, but rather take all these bots into a major network that cause a denial of service attack. Default passwords, IoT devices. That's a problem. Policymakers agree. A wave of IoT security regulation, California, Singapore, NIST, FTC, Europe, UK, all of that. A lot of it inspired by Mirai. Log4j, open source security. What do we get? Even more traction to the concept of the software bill of materials from the executive order. Even more focus on the important problems for open source security. SolarWinds, what do we get? Colonial Pipeline, ransomware payment. We have now a federal law on incident reporting and ransomware payment reporting. They are all connected. When we see something in the cyber attack surface, it impacts the way regulators think, where they pay their attention, and now they hacked. Okay, what am I talking about when I talk about security policy? Security policy is not your own company policy, but also this landscape of laws, regulations, standards, contracts, and code and design. It's a complex area, but it's also an inspiring area. Because remember Disclose.io. Disclose.io is an initiative that uses contracts. So policy is not just laws. And change can happen through code and through contract. What are some of the key principles in this space? There is one thing I know about hackers and attack, right? It varies. It's not just lawyers saying it depends. Hackers say that too, right? Because it depends on the stack, it depends on the environment. Sometimes it's the OT, physical. Sometimes it's a small IoT device, or maybe it's the grid, maybe it's the cloud. Environments matter. So we have all these different segments and business models and the software and the SaaS, but we also have all this jurisdiction. It's a complex planet, right? Exactly like in our space kind of thing, where you have all these aliens, but they all come together to the Star Wars cafe, and somehow they all kind of understand each other, although all these aliens, right, are coming from different nations and different policy spaces, and some are doing standards, and some are doing policy, and some are hackers. That's what's cool about this planet, which I hope you come and join us too. We have all this global interaction, and we have this convergence of security and AI and privacy. It just means that when it comes to policy in cyber, we have a lot of principles. We think about leveraging standards and technical documentation. We think about flexibility and this idea of design neutrality. Why? If you put in the law the concept of passwords, guess what? I hope passwords become a thing of the past. Maybe you should think about using the term authentication. Cool, that's a little bit more future-proof. All these different considerations is what come in mind when me and my fellow peers are speaking with regulators and policymakers. I invite you to learn more about it and check this out, but without further ado, I want to invite Harley Geiger, good friend, inspiration, mentor, to take the stage and invite you to participate in the Hacking Policy Council.
Hi. Thank you very much. Hello, BSides, and Amit, thank you very much for inviting me on here. I really appreciate it. So I'm going to talk a little bit about hacking law and policy, sort of how it has changed and how that is the result of community action. And before that, though, like Amit, I'm a lawyer, but this is not legal advice. Please do not get me in trouble with my law firm. If you need legal advice, then you should get a lawyer because they are really great. So I'm going to talk a little bit about the CFAA, Section 1201, and state laws, and how they've changed just in the past few years, some of the progress that has been made, and then some of the challenges that are still left. So by now, I'm sure that all of you know, the vast majority of our computer crime laws were created in like 20 or 30 years ago. And this has led to a chilling effect because it gave a lot of organizations, companies, government agencies, leverage over security researchers to say that what they're doing, their security research or their vulnerability disclosure, is somehow illegal, and it gives them the power to stop it. The CFAA, it was a big one, right? So that is our nation's premier anti-hacking law, and it restricts accessing a computer without authorization. But obviously in the past 30 years, what qualifies as authorization has changed quite a bit. It's become a much bigger gray area. And for a while, a lot of courts were issuing opinions that stated that if you were violating terms of service, that you were exceeding your authorized access, you've lost your authorization, and this is a federal hacking crime. But for security researchers, that's what they do all the time, right? Like they use computers in unexpected ways to get unexpected results. And so CFAA, terms of service violations being an anti-hacking crime, suddenly became a big problem for them. Section 1201, that law says that you cannot circumvent security safeguards to software, even for software that you license yourself, right? So if you own a device yourself and you have it there, you own the device perhaps, but you're only licensing the software. And if you're circumventing software security safeguards without the authorization of the software manufacturer, and who gets the authorization from the software manufacturer first if you're doing it independent, right? Then you have violated Section 1201. And although the CFAA gets a great deal of attention, probably most of you are from some state here in the United States, Every state has its own version of the CFAA. The CFAA is not a preemptive law, it's a federal law, but each state has its own computer crime law. And most of those laws are actually more broad than the Computer Fraud and Abuse Act, believe it or not. If you look it up, you'll see it's the same sort of verbiage, but they also include other provisions or they take away other requirements that make them, in fact, more broad. But in the past 7 years, and I'd say especially in the past 3 years, there's been a tremendous amount of progress. You've heard a great deal of it from Amit here already, right? But so Section 1201 now has a pretty robust security researcher exception for it. It covers a lot of security research. The CFAA, there was the Van Buren decision, that is the Supreme Court decision, and the Supreme Court rather definitively answered a lot of the terms of service question, stating that if you have authorization to access a computer for one purpose, like personal or employment use, then if you are using it for another purpose that is perhaps not authorized, this is not a CFAA violation. So that personal or employer computer, if you're authorized for that, independent security research is not by itself going to be a CFAA violation. In addition, right after that Van Buren decision, the Department of Justice issued a charging policy change saying that their prosecutors would decline to prosecute good faith security researchers. And it was based on the Section 1201 exemption. The state of Washington actually has an exception for white hat hacking, is a carve out from their computer crime law. And then some nations are following suit. Belgium recently issued a safe harbor from its nationwide computer crime law for security researchers. And then globally, we're seeing a lot more adoption of coordinated vulnerability disclosure and vulnerability disclosure policies, which will help a great deal by avoiding misunderstandings and conflicts between researchers and the organizations that they are disclosing their vulnerabilities to. How did we get here? How did all of this happen? It's like Amit said, the community has been absolutely key. This has not been by a single driving force. There's no single lobbyist or single organization or single security researcher that has made all of this happen. It has been community engagement from the ground up. It has been organizations in the nonprofit sector, government officials who are friendly and motivated and passionate about this, a lot of industry figures, a lot of academics, and I think most importantly, countless decentralized individual interactions between the community and policymakers. That's how it happens. This is very much a ground-up sort of effort. But there's still a lot to do. I expect you to read all of this. So this is just the charging policy. So the charging policy that the DOJ had issued, what it says essentially is that an attorney for the government, so a prosecutor, should decline to prosecute somebody who is acting performing good faith security research. And they define good faith security research. So you are doing it for good faith testing, investigation, or correction of a security flaw in order to strengthen the security for users or for the class of machines that you're working on. And you're not doing it in a way that can cause harm to the public. But there's limitations. It's not going to protect you if you're doing something like extortion, right? So it's just for good faith security research. There's a glimpse of the researcher exception under DMCA. It's virtually the same thing. This has become the sort of the definition of good faith security research that we're seeing kind of percolate throughout the law right now. Same thing, if you're accessing the computer for purposes of investigating and correcting a security flaw, doing it for just that purpose, and you're doing it in a way that's going to avoid harm to the public. There's Washington. You can see there in the highlighted portion, that is your white hat security research exemption in the state of Washington for their computer crime law. So a lot of progress, and these things are meaningful. It's not often that a class of professionals like this gets carve-outs from the law specifically for them, and it shows the power of that community engagement. Some of the things that still need to happen, though, greater adoption of coordinated vulnerability disclosure. I mean, it's still a minority of organizations that have vulnerability disclosure policies. The Cyber Resilience Act. So this is a proposed law in Europe. It's going to be huge. We're going to be talking about it the way that we talk about GDPR right now. But it'll take a while to get through. But one of the provisions of that law states that you must, if you have a vulnerability that is exploited without authorization, which again is that funny concept, which includes good faith security research, right? If you're doing it without authorization, that exploit or that vulnerability must be disclosed to European government agencies within 24 hours. 24 hours, it is not likely to be mitigated. So you imagine, this applies to all software in Europe. So imagine a rolling list of software packages with unmitigated vulnerabilities. That will make vulnerability disclosure a lot less welcome, right? If you're disclosing it to an organization and they have to go through all that. State anti-hacking laws, I mentioned. So the state of Washington, wonderful that they have an exemption. However, that's the only state that I know of that does. Right? So there are tons of other states out there with very broad anti-hacking laws. They have not evolved the way that the CFA has. There's no Van Buren for the states. There's no charging policy like the DOJ did. That was just for the CFA, does not apply to the states. DMCA, so there's that researcher exception. It protects the act of research, but it does not protect making your tools public. So this actually applies to all penetration testing services, believe it or not, as well as making your exploits public. The DMCA actually prohibits this, and we're all just kind of whistling past this regulation. But it's there, and there is no security exception. There's no possibility of a security exception for it without an act of Congress. And then OFAC sanctions. We don't believe that receiving a vulnerability disclosure from an OFAC sanctioned entity ought to be an OFAC violation. And to address some of these issues, we made the Hacking Policy Council. Thanks. So the Hacking Policy Council is a group of companies that have gotten together to make a more favorable legal, policy, and business environment for vulnerability disclosure, good faith security research, penetration testing, vulnerability management. Right now, that group of companies is Google, Intel, BugCrowd, HackerOne, Integrity, and Ludus Security. And together, we're working on the issues that I just discussed. So the Cyber Resilience Act, there's that article. Again, don't expect you to read it, but feel free to take a picture. This is Article 11. If you have contacts with the European government, I suggest that you reach out to them. This is a terrible policy. We think that this raises intelligence concerns. It's going to require vulnerabilities sort of disclosed to perhaps dozens, upwards of 50 government agencies each time. OFAC. Right? So as we increase security, CVD throughout the world, it's going to result in more vulnerability disclosures to more organizations, and we don't think that that should be disrupted. That is a good thing for the community. We want organizations to get their vulnerability disclosures. We don't want sanctions to be one of those things that gets in the way. We have an export exception for it. We need one for OFAC now. And then just an example of a state law that is in dire need of some reform. This is Maryland. Home of the NSA, and if you even attempt to identify a valid access code, if you even attempt to identify a hard-coded password in an IoT device or a default password in products that come out, like a friend of mine, he built the defaultinator, right? Then apparently in Maryland, this is not legal, very outdated. And then despite all that, even if we get through those things, and despite the progress that we have still made, right, there are still going to be instances where security researchers are facing legal threats for good faith security research. So the Hacking Policy Council is taking on policy advocacy. The Security Research Legal Defense Fund is supposed to help take on the judiciary in a way, right? So this is a defense fund that will be able to provide financial assistance to security researchers that face legal threats for good faith security research. Like the DOJ charging policy, it's not interested in protecting you if you are engaging in something like extortion. But for a lot of hackers that receive sort of bogus threats and cease and desist letters, the Security Research Legal Defense Fund can help you pay for your lawyer to combat that. So this is my last slide, then I'll turn it back over to you, Amit. Going forward, right, there's still a lot to do. I don't want people to think that because we have made tremendous progress as a community that that's the high water mark, and now we will just kind of take it easy. I don't think that we can, right? So as cybersecurity laws ramp up in many different sectors and throughout the world, these same issues are still going to be there. I would encourage you to focus not just on federal, but also state, local, international, right? A lot of the federal law gets most of the attention, but your states, it would be a great place to make your voice heard. And that will be the key to continued progress, is community engagement and making your voice heard. Hopefully one of the things that these presentations have taught you is that it works. Policy advocacy does work, but it works best when the entire community is engaged and the entire community shows that it's a priority. All right, thank you.
Thank you.
Oh yeah, you don't need that.
I don't need that. Yeah, I have my app. Can we make this work? Is it working? Yeah. Yes. Okay, cool. The good news and the bad news, I'm still talking. The bad news, we won't have time for questions, but I'm going to stay around. So thank you, Harley, and the venerable disclaimers. I'm going to fast forward this issue on product security. All I'll tell you is this. Remember what GDPR due to privacy and compliance. Remember how we all talked about it? The EU Cyber Resilience Act, in progress, is the most comprehensive, holistic, complex regulation, and it's going to apply to all products coming into Europe. This is very important. So try to engage. But in the beginning of this talk, I told you that I'm leaving Intel. And you're probably asking yourself, why? Or maybe you're not asking. Maybe it's pretty clear. But Intel has been amazing to me and taught me a lot. And in the last 4 years, I've been handling the cybersecurity policy. And today, I head the cybersecurity policy at Intel. And I also chair a couple of committees, like the ITI committee and the Open Source Security Foundation committee, all these trade associations. And with these trade associations and coalitions, we have done a lot. But you just heard from Harley that we are asking you to engage. But how and where? Not just in conferences, not just here in the room. How are you going to be really, truly empowered to engage? How are we going from a number of companies and trusted members of the communities and advocates and all these people here that want to make that change into reality? Well, that's my next big thing, open policy. We are still a little bit in stealth, but you're getting a preview right here. Hopefully the video is not going up soon. My goal is to democratize policy and truly engage with all entities from all sizes, seed, startups, hackers, individuals, unicorns, with policymakers, to get educated, to understand, to make this important relaying of cyber policy and beyond open to more and more and more parties that want to engage and impact that change. But we all know, for true openness, we need technology. So hopefully, what I view is for the first time, I'm going to attempt to disrupt lobbying. And I'm not doing it alone, but I'm pretty excited. Open policy is going to be access to policy powered by tech. Keep it a secret. Don't upload the video yet. We are a little bit in stealth, but that's my next big thing, so stay tuned. May 1st.